Excellent.
Okay, so everybody, welcome to our very last webinar for this academic year, and I am so very grateful to Fahira that she's accepted to do this webinar for us, which is quite topical, and our management committee executive, Hussein Haeri KC of with us I'm going to hand over to him. So he's the one running the show. I'm just going to be in the background, and Fahira, I will ask questions. Hussein.
No problem. No problem. Looking forward to it. Thank you.
Thank you very much, Professor Onyema, and a big welcome to everybody to be with us for this final webinar of the academic year at the SOAS Arbitration and Dispute Resolution Center. We are delighted to have with us today Fahira Brodlija to speak on a very important and timely topic, the reform of investment law and dispute resolution. When will states reap the benefits of a decade of reforms? Fahira is an advisor for international investment law and dispute resolution in an important regional GIZ legal reform program in the Western Balkans. She's an adjunct lecturer at the International University of Sarajevo. She's taught at a number of other international universities, including Columbia University in New York, Bocconi University in Italy, and the College of Law Chrisland University in Nigeria. She's also a lecturer on the Africa Arbitration Academy program. She's authored over 50 articles and has co-edited 3 books on international, commercial, and investment arbitration, while contributing chapters to many others. So we're delighted to have you here with us today, Fahira, on this topic. I think you have some slides. And if I may, by way of introduction to this, ask you an initial question. There will be scope for questions at the end as well. But if I may, I'd like to kick off with a question on this topic, which is, we hear a lot about the various reform processes that are ongoing, and in particular, as they relate to international investment law and dispute resolution in this context. What is it, in your view, that has prompted this ongoing reform process at its inception? Thank you.
Well, first of all, let me just extend my deepest gratitude for the opportunity and this wonderful forum. I have been following for a while now, SOAS and in the Africa Arbitration Academy, the annual debate of the Titans happens there as well. So it's been an ongoing journey of love and respect, especially for Professor Emilia. So I couldn't be happier to have this opportunity to speak to this forum and then exchange ideas. As I mentioned, I think previously and in our discussions, I really prefer to have open discourse, to have a dynamic, discussion. So after these initial inputs and presentations, I'll be more than happy to take any questions and just to hear the views of the audience, because this is a process that's ongoing. It's severely consequential. There are some angles that are more radical than others, some seeking to abolish investor-state dispute resolution altogether, some seeking to find some more tangible and more concrete solutions of procedure. But either way, the consequences of these cases are huge in monetary terms, in social and cultural and just political terms, and especially on the latter. In recent years, as we see the global shifts in the dynamics of trade and investment, economic flows, global conflict, the energy sector, in its tension constantly to find stability while also transitioning to a greener practice and future, which will accomplish the Paris Agreement goals. So a lot has now somehow seeped into this concept of investor-state dispute settlement beyond what it was previously envisioned for. Previously, it was basically a balancing, neutral international framework where investors from usually the Europe and from the US could now venture into previously unknown jurisdictions invest, develop, also fostering jobs and development there, but also protecting their legal rights. In recent years, as these cases have proliferated, it's become fair game. Cases are coming from the developing world to the developed and vice versa. Within the EU, I'm sure many of you are following those developments, and you know what's happening with the anti-ISDS policies and basically declaration that it's contrary to EU law within those borders. So overall, this is the context in which we are talking about now the reform of ISDS. So as I'm sharing my slide, I hope that you will keep this in mind as we discuss further, and that then we will be able to engage in a little bit into a conversation. Now let me quickly open this up and we can start. But I would just like to initially, by raising your hand, show me how many of you are following either the development of the investment treaty law or investment dispute resolution. How many are following the reform? I would be very interested to hear or to observe. So if you don't mind, just quickly. All right, all right. So we do have some already pretty mature views, and then also we have a lot of people now who we have to pay attention to and bring them over to an understanding. All right, I do not know why it's not happening. Never mind, I will simply show. Go entire screen. Hussein, do you mind sharing? It just does not give me all the options that I would need. And I don't want to waste any time. I'm very excited to start.
I would ask Hannah maybe if she might be able to help
Do
us
you
out.
have you, sorry, I can't find the slides from my end. Let me see. There you go, yes. In a second. Okay, so sorry.
All right, fantastic. So I have gone through the outline already, so you can skip to the third slide.
This one. This one or?
No, they're not changing for us. I
Oh.
can't see them changing. Let me just send it to you, and now I'll just start speaking so we can keep the dynamic going. So basically, what we're talking about in the background is this so-called anti-ISDS. You can skip the outline, yeah. The anti-ISDS movement and the generally just the backlash against this framework for resolving disputes between investors and foreign governments, the host states of their investment. And this tension has allowed a lot of room for discussing the legitimacy of the system overall. And as states are really trying to navigate all the previously discussed movements globally that we have discussed, that are much more consequential than simply having, deciding which kind of dispute resolution mechanism we want. We have then discovered the real impacts of these cases, and they have become the benchmark of the progress being made or the obstacles in the way of the necessary reforms that the states have to take. And this is all in the background of the immense amounts of sustainable investment, which means that regardless of how you feel about ISDS, you will still need to have an ability to attract these investors and protect them without infringing on these rights and on these opportunities. Let's put it that way. Hannah, are you able to expand fully?
Yeah, let me try. Is the slides going with you, or it's not? Is it stuck?
It's moving. It's moving.
Okay.
Let's see. Okay, I managed to share, so I can do it this way.
Okay.
I have this now under control. Can you confirm everybody sees this the way it should be seen?
Yeah.
All right, now we can really start. So in essence, there are some identified concerns that the states have, and that ISDS, just like any other process, can be continuously improved. And there are some very concrete things that have manifested themselves in these ISDS cases that are procedural, that can be addressed, that are already being addressed, and that can fully function and properly enable a framework of reform that will bring short-term but tangible changes. So this would refer to, for example, the consistency and coherence of awards. So governments have been complaining for a long time that the interpretations of the old generation investment treaties that they are so used to applying, that make up the vast majority of the body of these different of the treaty network of different governments, they have been interpreted in unexpected ways, leading to unexpected outcomes beyond perhaps what states had in mind at the very beginning when these treaties were negotiated. But then also, they come with large damage awards. And these damage awards can be close to, and in some cases even amount to, a multiplicity of a state's whole budget, or perhaps a budget for a very important ministry, like the Ministry of Health, the Ministry of Education, or the budget that they allocate for climate change mitigation or sustainable development and investment efforts. So all of these things come at a price because of the perceived inconsistency and incoherence of awards. Then there's a concern of the independence and impartiality of arbitrators. States often have a problem, although they benefit from appointing arbitrators themselves and selecting them. Their complaint is that these are usually private lawyers, practitioners, or arbitrators by profession, who are detached and not accountable to states, and they are just simply appointed on an ad hoc basis without a robust enough system of accountability. Then the concern about the duration and cost. Many practitioners will often brag about the efficiency, both cost and time efficiency of arbitration, but in recent years that has been refuted in commercial spaces, but also in investment arbitration, especially where you have cases going on for almost a decade, for years, not to mention afterwards and set aside in enforcement proceedings, especially those implicating the European Union. So this is a very important consideration and concern. Again, broad treaty interpretation that connects to the first point of the outcomes and the consistency, and large damage and cost awards. And finally, this sort of catch-all concern that goes to the substance and the procedure, which is the state's right to regulate. There is a perception, which is difficult to prove, metrically, because you don't know how many times the government might consider a policy and then give up because of the threat of ISDS. So you can imagine how this threat could also be seen as kind of a universal get out of jail free card against liability and a defense for states, that they are concerned the ability of investors to sue them in investment arbitration for large amounts of money will then ultimately cause them to either give up on the necessary policy reforms, especially for climate change mitigation, or that they will have to reconsider and still adopt these policies, but face investment claims and liability. So that is the balancing act. So as the states now are considering the reform of this, against the background that we just mentioned, they are taking certain things into consideration as a general matter before we venture into some specific reform processes. So they do take account of the lessons from the proliferating case law from the past. Although there is no system of precedent and there is no stare decisis and investment arbitration, there is a lot that can be drawn procedurally and substantively from previous cases. There's, this context of the backlash against ISDS and the introduction of new treaty restrictions for the access to investor-state dispute settlement as we know it. Also, trying to fit and integrate climate change and energy transition, human rights, very important considerations into treaties that are fundamentally economic and investment in nature, and were aimed at protecting foreign investors for the economic prosperity they might be bringing in without that much attention given to their impact and the need to explicitly restate, for example, the principles of no harm and principles of mitigation or the state's right to regulate for public interest. And finally, and again relatedly, these new treaties will have to then, no matter which direction a state might go, they will have to consider balancing the state's public interest with the investment-backed interest of the investor. So knowing just how much good investment we need, we're no longer talking about finding protection space for fossil fuel investors or any entities that might be harmful in that sense, but really trying to balance all the regulatory instability that might come in the future with the protection of the interests at the international level of foreign investors, which are so heavily needed. So to illustrate what I have just said, before we transition to the next kind of area of discussion, this is pretty much what it looks like. States have a concrete view of what they need and what their reform priorities might be when it comes to these reforms, multilaterally, but also especially nationally. And then you have the anti-ISDS narrative, which comes from usually bigger movements. It comes from also NGOs and generally independent commentators who amp up and continue on the narrative, which is also very prominently advocated by the EU as well, as they pursue reforms that would introduce a more judicialized framework, which we will discuss in a moment. So Hussein, I would pause here now and to see if there's something else where I should be directed next.
Thank you, Fahira, for that fascinating introduction to the issues. I mean, I think, it's interesting to understand what the main platforms and frameworks are for these discussions and developments, both at the multilateral and also, in some cases, at the individual and national as well as bilateral level. So how would you, disaggregate and consider the various platforms and initiatives?
Yes, well, it's very difficult actually. So I'll start by just putting things in the big picture. The reform instruments and guidance and models and fora, all well intended, all well developed and beneficial ultimately, are compiling. And they all come from similar yet distinct angles. They come with different kinds of tools and mechanisms. They have access to different groups of states or other stakeholders, which ultimately fragments and complicates for any states trying to engage, in a very comprehensive and robust way in the consequential reform. Because remember, states cannot afford to change their regimes and their approach all the time. The investment treaty framework is not susceptible to such an instability, especially. And practically, logistically, it takes a long time. It takes a long time to develop a model treaty, let alone to develop and to negotiate a bilateral, regional, or multilateral treaty that will have effects, as soon as it's ratified. So academically, it's wonderful. It's a really fascinating thing to witness, the ideas that are coming out, different tools and mechanisms, but they are compiling and it's becoming very challenging for states. So in my work with the Western Balkans, which is always politically challenging, and it's a small region, but there's such difference between different stakeholders. It's already enough to try to get them to some sort of a cohesive baseline of reform to avoid fragmentation and to facilitate their economic development. But now imagine multilaterally. Imagine then, how do you keep the states interested, and how do you prevent them from just giving up on these multilateral reforms and moving along with some, unfortunately, usually protectionist policies, which is kind of a reflex in some areas. So we'll discuss the main point, which I'll give the most attention to, is how do we devise then something out of all of this that will be fitted for a specific state. But just in general, there's a lot to look at. So, for example, there is this dichotomy, no matter what certain organizations that are undertaking these multilateral reform processes might say, it is a pretty visible and obvious dichotomy between procedural and substantive reform. And what I mean by that is procedural in the sense of reforming the process of investor-state dispute settlement through investment arbitration, and of course the surrounding procedures that might be available in the cooling off period, which is the amicable settlement phase, which is increasingly now being referred to mediation explicitly so. But that's the framework. So how do you make the process work? Because remember, ISDS in its pure sense, when it comes to procedure, is a process. It has become a shorthand for everything that's wrong. It's a price tag for government harm cost to investors. It's a price tag for the budget as well. It may indicate some state measures that are not aligned with international law. So it is the poster child of everything the state does not want. But in essence, until you feed into any process the underlying treaty, the underlying law, the applicable legal framework, it is truly a process that can be navigated, especially something as flexible as arbitration. So the parties could, in discussions with the tribunal, always create a space for a procedure that will be functional for them. But now, luckily, with the reform, it will be easier. So that's kind of the narrow view of this. But in investment dispute settlement, it is inevitably more difficult to separate these things, because the methods applied by the tribunal to interpret the qualities and the ethical standards and process for their challenge for the arbitrators, the different available procedural tools and mechanisms and due process considerations, they are all now being applied towards a sovereign as well as a private party, which brings the claim. But with the sovereign element, now you have a heightened degree of sensitivity. And states, when they approach the reform process, they have never fully decoupled procedure from substance. Procedure meaning investment arbitration, substance meaning investment protection standards and treaties that are applied to the proceedings. For them, in the reform process, generally for ISDS, they are constantly calling for both and not distinguishing them. And this is why when I previously explained the main concern, some of them are purely procedural, some of them are really about treaty interpretation, and outcomes of cases and damages. So that is obviously not in the domain of pure procedure. Obviously, it's much more of a substantive side and depends on other factors. So currently, the procedural reform is primarily being conducted multilaterally within the UNCITRAL Working Group 3 ISDS reform, which we will discuss later. It is basically a state-led process developing now reform tools and solutions based on the identified state concerns with the existing practices in ISDS, and then developing concrete solutions for hopeful reform within that framework, that with the assistance of UNCITRAL, their secretariat, experts who collaborate with them, ICSID, and others. Then we have the recent reform of the ICSID rules, which apply strictly to investment arbitration, and which have already introduced significant advances, responding in part to a lot of the UNCITRAL Working Group's 3 concerns, with more transparency, more efficiency, more clarity, which is very important, of deadlines, of procedures within the ICSID framework. So that is already available for direct application. And then on the other hand, you have the EU approach. As I mentioned before, they are envisioning a more judicialized framework where you would no longer have party appointments of arbitrators. You would no longer have primarily investment arbitration. You would now have a semi-court or quasi-court or a court system where there will be a standing framework, judges appointed long-term, who would not be allowed to take any other roles and would be therefore randomly assigned to cases, but being appointed by states to the body of the roster. So the EU envisions this right now, and it has integrated in its recent treaties, trade treaties with other countries which are outside the EU. But ultimately, through the Working Groups 3, they are now workshopping and developing a multilateral investment court, which would expand then to any government around the world that would sign the statute or the treaty establishing the court. And then all the investor-state dispute settlement proceedings would be referred here and resolved under those rules. So that's the procedural reform landscape at the moment. And on the substantive reform side, you have the national, you have the international framework and assistance, and they really feed into each other more naturally, unlike in the procedural realm where there's a need to kind of separate things more. And on the substantive reform, governments have increasingly been developing modernized model investment treaties, which are being negotiated now actively. Many of the multilateral treaties with robust and modern sustainable provisions that are incorporating everything that we mentioned that's necessary have not fully entered into force yet, so we have not seen them in practice. Neither them on the substantive side of protections and their effects on these global movements, but also just generally how they might play out in disputes in different fora. So the new treaties provide calibrated investment protection provisions that limit the discretionary interpretation space for claimants, but also for tribunals. This especially refers to the fair and equitable treatment standard, which has been the most frequent and the most successful provision in any investment treaty when it comes to ISDS in recent years, especially for renewable energy investors. And the concept and principle of legitimate expectations, which has kind of been born out of the broad interpretations of FET, but it has never been explicitly acknowledged as a part of it. So now you have more robust provisions, for example, on FET that either exclude explicitly legitimate expectations as a standalone protection for investors, or simply they say it can be a consideration for the overall assessment, but it does not grant any standing to a claimant themselves. And like I said before, we have the provisions on sustainable development and climate change, and these provisions are explicitly mentioned almost always in the preambular text, but you also have them now in separate sections. Unfortunately, most of them are still, aspirational, not so direct and consequential and actionable, in the sense that they would have consequences for either the investor or the state, so that they can either be offset in the damages award, or they could be asserted against the investor in counterclaims, or maybe even used to dismiss a claim for any action of the investor. So there's a lot to work in that area. But the main international organizations and fora that have enabled very robust and very high quality analysis and policy tools, and continue to do so, are UNCTAD and OECD, which are working, UNCTAD more on the general framework for international investment agreement reform, but UNCTAD is focusing in two tracks: on modernizing the existing network of investment treaties, and also introducing sustainable and climate change related provisions into their framework. And just kind of to outline what it looks like, it's a very complex process. So each one of these is very complex. And you can see on the left-hand side, the UNCTAD framework. These are all different phases and branches of reforms that need to be addressed by governments, and you can see how it can be very challenging. OECD as well, with the ongoing discussions on two tracks of reform and the exchange of written analysis and submissions. And finally, the House, the UNCITRAL Reform House, that provides the different, as they call them, building blocks of reform that could kind of, reinvigorate and reinforce ISDS as we know it, or in any other form that might come out.
Fahira, I don't think we're seeing the slides changing actually as you're changing them.
Ooh, where are you standing?
Says consistency and coherence of awards on the top left.
Oh no, why didn't you tell me before? Oh my. Hannah, are you still sharing?
No, I'm not. I'm not sharing.
Okay, let me try like this. Are you seeing anything change now?
No.
You see the cartoon?
No, it's the same slide.
Oh no, hold on. What can be? Maybe if I do it like this. So nothing is moving?
Fahira, do you want to stop sharing your screen? Let me see if I can share mine. I have your slides.
Do you have do you have these most recent ones?
I think the one we have is not the most recent one. No, it's a bit different from.
Yeah, because I sent along a couple.
Should I check and see if I can?
Let me send. I'm gonna send you, Professor Emilia.
Okay.
And I'm gonna just keep talking.
Okay, please.
I'm gonna send you all. Yeah.
Okay, thank you.
We don't waste time. So as a general matter, as I mentioned, I would just like to give you an example of something concrete in the UNCITRAL reform process as a kind of case study of the dichotomy of expectations and realities for states when it comes to these reform processes. In the global, landscape of government, it's very difficult to imagine that they all will accept or consider as relevant the same kinds of reform directions. So the mandate of the UNCITRAL Working Group 3 was to develop a unified, harmonized framework, binding rules rather than guidance. So it was not supposed to be another soft law instruments. It was supposed to be government-led, effective, and it was supposed to be enforceable. So overall, that was the main difference between the UNCTAD Working Group 3 and all the other, periodical reviews and periodical discussions and different tools that were issued by very significant and valuable work from international organizations. However, when pen hit the paper, things change. And it becomes increasingly difficult to reconcile the different interests, especially as the EU promoted multilateral investment court, or at least its elements became more incorporated into these discussions. And there was kind of a shift away from the concrete procedural, granular, and gradual reform that states wanted. That's when it became more difficult. So what we have in reality, if we look at the actual results and solutions offered so far in the UNCTAD Working Group 3, they are pretty much addressing compromise solutions. So they're not as strict and universal as previously envisioned. You have this building block approach, meaning that, and it was actually explicitly stated a couple of years ago by the Secretariat, that even if there is no consensus on all of the reform proposals, the reform will be considered accomplished once it's finished, once the process is done. And that was not the original mandate or what was expected from Working Group 3. Then also there's this issue of, okay, now we see the cartoon. So you should have seen this a long time ago.
Okay. Okay.
Yeah,
so
I can see it. Thank you so much. And is there a way for me to take over the sharing?
Let me see.
Or you can,
yes, maybe for now I can just.
Yeah, so just move on to, you can move on until you see that house, those three pictures together. So, and then the next one, perfect. This is the one. The next one. Excellent. So, and with the building blocks and then no specific enforcement mechanisms that will be developed specifically for ISDS and for this kind of reform, it is very clear that the way the mandate was framed and what governments in different regions expected and needed versus what's being given in these solutions is not the same. And this is not to say that it's not impressive what was accomplished so far. It is only that governments leave less satisfied. We still have space for a lot of fragmentation and not as many clear answers. We do need a lot of structure. We need a lot of clarity, if not harmonization, which is basically impossible in this space. We do need a cohesive approach and predictability. And what this reform process has yielded has not fully been in this area. So Hannah, please, can we move on? So this is another visual depiction of what it looks like. So basically you have all the desired procedural changes in a bucket for procedural and cross-cutting issues, which are now discussed as one topic. You have some watered down, compromise solutions that are still subject to party discretion, tribunal discretion, not really devising rules that could be directly enforced. And you have a lot of low-hanging fruit, which is not controversial. Do we need a code of conduct for arbitrators? Yes. Would it be good to have guidelines and model clauses for mediation to try to prevent or mitigate disputes? Yes, of course. And there's this idea of having a framework treaty for ISDS reform, which would offer all of the adopted and developed solutions, and then the governments can take them. So you take from this framework treaty what you need from the menu and put it in your treaties and your rules. It's practical, it's very useful, it's similar to the approach of the Mauritius Convention, but it does not still bring the stability and the proper reform that's necessary. And then, as I mentioned, the systemic reform, meaning institutional, structural, where we have discussions about the multilateral investment court, the appellate mechanism, and the advisory center to help governments that don't have so much experience or have difficulties in navigating ISDS still. So again, it's compiling, it's very robust. Many things are considered, and yet on the one hand, there's too much. On the other hand, it doesn't seem to address the concerns the states primarily have. So in our experience here in the region, that was the main challenge. How do we keep the states going? How do we keep them interested? And how do we bring them to a framework where reform makes sense and where they will actually engage properly, so we come out of the system and of reform with something that they could use and that will be beneficial to them. So I think, you know, maybe that's the most interesting thing that everybody's waiting for. But Hussein, any further points?
Well, I think that's probably exactly, yeah, what we'd like to understand is how are individual states in the Western Balkans, for example, you know, adopting these different initiatives in a way that they can progress their own position, because obviously it's difficult to see a kind of a unified or harmonized picture at the multilateral level. So how does this play into kind of national approaches from your experience?
Mm-hmm. Hannah, would you mind moving the slides? Oh yeah, this is another one. So I just like to put things into a kind of witty relief before we transition to the actual operational things. But this is what it looks like for states that are looking for very concrete and actionable solutions, and they are just faced with a lot of options, none of which are within their reach right now. And it's kind of a sober reminder of where we stand. So Hannah, please. So our approach was basically to, instead of seeping all the reforms from above and trying to retrofit the globally developed solutions into the national systems, we went up, you know, we went from the bottom up, meaning we wanted to create a framework for these governments to establish the data analysis and generally mapping of the instruments and cases that are within their jurisdictions. First, to see where we stand. So establishing the status quo of the framework treaties and also of the procedures of their cases and institutions. Then to identify the common risks and challenges and arising priorities. What is it that the states see that needs to be addressed to enable them to fully proceed to participate in these cases better, but also not to be stifled in their policy space. And then finally, to develop tailored solutions for each country. There is no replacement for government-to-government solution, no matter what, you know, might be available and how robust certain international offerings might be. Each government is a story for itself, and for them, it's very frustrating when they're not able to, or they're simply not able to adapt while being forced to reform. So tailored solutions, ultimately, no matter when it might happen, they are ultimately the ones that can bring the real results. Next, Hannah. So this is what this mapping would look like. Basically, we look at the international investment agreements from quantitative perspectives. So how many, what are the economic implications, what is the volume of investment coming from the governments with which we have treaties, but also qualitatively the provisions themselves. When they were adopted, what kind of protections do they provide? What kind of risks do they present to the government of exposure to ISDS? But also, how much are they enabling the prolongation of the climate change mitigation process, preventing actual necessary change to sustainable development and energy transition? Aside from that analysis, we also do the mapping of ISDS cases, which also reveals a lot, especially when you place cumulatively one government's experience into one framework for analysis. So you have, categories of data such as the nationalities of claimants, the sectors that are most affected, the legal basis for jurisdiction, whether these are treaty claims, contractual claims, legislative claims, which instrument is yielding the most of these claims and enabling the exposure of the governments. What kind of state measures are being contested? Are we talking about legislative actions or regulations? Are we talking about allegations of arbitrary or unreasonable conduct by the state? Or are these expropriation claims? What kind of issue is perceived as a breach of the treaty factually? And then we look at the substantive treaty standards, which were used to pack these legal claims and then take them to arbitration. And of course, the outcomes of these arbitrations. So all of this allows us then to look at the most sensitive areas. Where do we need to intervene, which then helps inform in the best way possible the key targets of reform procedurally and substantively that the government has to address, and then afterwards, of course, taking into account all of the other available and valuable reform options. I really want to repeat, this is not to disregard or dismiss any of the efforts and the tools, but still just looking at it from a different perspective and seeing how we can get this to states more quickly. And finally, we would map the institutional framework, trying to expand the reach of different kinds of methods and procedures to enable governments to defend their cases and hopefully even prevent and mitigate them. So you will look at the allocation of competences between the institutions. You would consider dispute prevention capacities as well as amicable settlement capacities. And these will mostly depend on how well coordinated the government is, because dispute prevention and amicable settlement are mostly about quick responses, being agile, having a good coordination and communication within the government, and also being able to communicate effectively with these investors at the stage when their issues are still grievances and have not escalated into a dispute, let alone a mature legal dispute that can go to arbitration. Anna? So when we approach the reform, there are some just general considerations that could be useful. So the governments don't have to wait for the end of the multilateral reforms. There is already a menu of options available for them to integrate into their reforms that they need. And luckily, that means they don't have to reinvent the wheel. All they have to do is find a suitable option and adapt it to their legal system and what is feasible for them, while leveraging everything that is at their disposal. So when it's a daunting approach simply to try to filter all of this, but with the right approach, having this baseline of data that we previously mentioned, then they know where to look and they know how to recognize what is going to enable them to address these concerns that they have already now seen as red flags and these analysis. Another very important component as they are reforming both process and their substantive protections is to include data tracking and management systems overall. So anything you're changing, any new mechanism, make sure that you are able to follow it, to continuously assess it, to draw conclusions from it and inform periodical reforms and improvements. And then you can have your own menu of reforms, and you can look for reform options or even initiate processes with other governments or organizations that can address specific areas. So hopefully in the future, we will not need to address everything at the same time. We will be able to have a particular, time and place and forum to have nuanced discussions of different things. But this will require tracking and following and understanding how these things evolved. And no matter what a government adopts ultimately as a reform, it's also important that they match these adopted reforms with institutional frameworks that can uphold them. You cannot overpromise in your treaties. You cannot overpromise in the rules of procedure, because ultimately you will be called upon it, and it can either escalate a dispute or it can lead to new ones. What you need to do, if possible, is as you're adopting something new that's a reform, beneficial for procedure or substance, make sure you institutionally have the capacity and the competence and the framework to implement it, so it does not fall on deaf ears or it does not create burdens ultimately, no matter what the good intentions were. Related to this is something called systemic integration. You cannot afford to have a robust, modern, fantastic investment treaty with provisions that are up to date and fully in compliance with all the international standards, and then have national legislation that investors can use to avoid these stricter and more calibrated provisions in your treaty, and still get the kinds of damages and broad interpretations that they would get otherwise. Investment contracts as well. The biggest corporations, the biggest companies, not the SMEs, they are the ones that have leverage to negotiate. Even in countries that abolish arbitration, or have a negative view, these countries, these companies which are considered to be too big to fail, they can afford to negotiate, and governments in some cases will negotiate with them still tools and mechanisms that might not be so beneficial for the government. So again, if you reform your investor protection standards and your procedures in one instrument, make sure that they are systemically integrated into all of those that can be the source of disputes, but also that regulate investment conduct, so you still have your policy cohesiveness and generally know what you can expect. And finally, something that's not really talked about a lot, PR strategies, meaning the government and their officials, as defensive as they might be, which is understandable, sometimes out of a lack of understanding, because not everybody in the government, especially those in the higher positions, might not know the nuances of the investment protection and ISDS framework. So when they're faced with a claim or a big award, they will come out, with complaints. They will come out with accusations against the investors, or they will come out with against some political party. It's very important not to have public statements that could be used before, during, or after an arbitration, but to have a cohesive messaging coming out in public, to have a cohesive messaging towards the investor, and then finally, whatever else may happen afterwards. The public-facing statements should not escalate or aggravate the issues, and unfortunately, sometimes that can also happen. So unfortunately, I'm going to have to skip through some slides. So Hannah, can you move? And I'll just say, yeah. So this is kind of showcasing how we sift through the priority levels. So the crossed out issues of independence and partiality, we're not saying they're not important. We're saying that we identified, for example, that the coordination of the government and the government measures rather than policies or the qualities of arbitrators led to ISDS and big ISDS outcomes. So when it comes to reform that's being actively conducted in a tailored manner, the ones that are not crossed out were considered to be immediate needs, and all of the others would be observed and taken then from the UNCITRAL framework. So ultimately, when governments approach this from a tailored perspective, they will have to filter and triage what can be, what is feasible and what they can do, and then take it in phases. At the same time, rethink their institutional frameworks and also the capacities of those who will be applying all of these things. Hannah? Also, we need to consider expanding the dispute resolution spectrum, as they call it. Oftentimes, not only do states become aware of disputes when on the far right end of the spectrum, when there's an arbitration filed, but the cooling off period that's available in the treaties where amicable methods can be explored are basically not taken into account. They're missed opportunities because of unclear jurisdiction or the lack of response from a government. So many things like that can happen. And not to mention the space before, the space during the implementation of the investment where grievances and issues come up, which is normal, especially, for example, in renewable energy investments, very, very long-term contracts and projects, and very consequential for states. So in this space, grievances and conflicts can be addressed. And importantly, this is the space where investors might not want to go to arbitration, but this is the timing where they will likely cancel an investment or reduce it, or they might withdraw or postpone. And the worst case scenario, an investor looking from afar at the system and the government and their practices might become aware of this disregard of prevention and mitigation, and might give up on investing without even reaching out. So imagine losing investments that you were not fully aware of because of the lack of agility or responsiveness. And the tools that are needed to remedy this are really available through coordination, and there's a whole robust compilation. Unfortunately, I cannot get to them all, but I put some useful links in the slide at the end so you can explore them when they're available to you. Hannah, you can keep going into the slides. So this is basically, I explained some of the pre-dispute reforms, so better communication roadmaps, focal points for prevention, coordination bodies for amicable settlement, where the competent ministries will decide together on the settlement and then communicate to the investor, so there is no appearance of any manipulation by a specific ministry or anybody else to clear that kind of concern. Hannah, again, another illustration of the same process. Yes, we move on. So I will just explain this, and I will leave the rest of the slides for individual explorations, and you can always reach out to me to the email if you want to discuss anything before or this one. But I want to be respectful of time, and I do want to open some space for a conversation. So I just want to say a few framework things for reform. One thing I have observed, and again, it's a reflex by governments, it is defensive and it is exclusionary when it comes to their reform approaches. So the more pressure governments face, on the one hand, from investment claims and big awards, and on the other hand, this pressure and urgency of regulatory reform, especially for climate change mitigation and energy transition. We have seen many countries simply terminating treaties, reducing investment protections altogether, introducing very long and defensive, exploration and exhaustion of domestic remedies clauses. So just by the framework of this system, there's a tension, there seems to be a distance between the government and the investors. And in order to have a robust and really effective future-oriented reform, we have to consider reorienting also the perspectives and the attitudes. So investment treaties, investments, foreign investors, and dispute resolution mechanisms should not be primarily viewed as obstacles to all the progress we need to make. But by introducing the right changes in institutional frameworks and rules, we can now, talk about states' right to regulate. States can, and they're the only ones who can, use their treaties as canvases to infuse them with the kind of calibrated provisions, the kinds of procedures, envisioning the application that they would have in the future, which only they can understand from their policy perspectives. And they cannot be introduced or transplanted from 2 decades ago and 3 decades ago when the older treaties were adopted and entered into force, nor can they be projected from some universal set of discussions. So these canvases then can envision also foreign investors, for example, in the renewable energy sector, as a part of their public policy interest. You need them, and the disruption that comes with conflicts and disputes that are either not resolved, so it results in lost investments, or go to arbitration resulting in large damages, it is still disruptive to energy transition. These investors and their companies should be ultimately contributing to your efforts. So the policies will have to balance this important interest, but it cannot be done if the scale is only weighed on the defensive and kind of adversarial approach from the very beginning. And then you can integrate all the kinds of provisions you need, protect the ultimate international values, and integrate these values into the new generation treaties. I wish I could tell you what it would look like. None of these new and beautiful models that we see have been tested in practice, like I said. Let's see what happens, and hopefully they will not be interpreted through disputes. They will be interpreted through ongoing collaborations and reforms that will be aimed at that. How do we move forward in better frameworks rather than being reactive to the harm and the perceived obstacles to progress yielded from the system? So unfortunately, I couldn't really get to everything. As you can see, it's a close topic to my heart and my work. So I could go on. I will stop here in terms of presentations, and you will see now some procedural options. I integrated there other kinds of reforms that could be considered. Hannah, could you just move to the useful link slide? So almost at the very end, yeah. There we go. So this is where you can find links to different tools, different adopted instruments, different cases, everything that you can find useful. I hope you will explore over time. So thank you.
Well, thank you very much, Fahira, and also for the call I heard for balance in what can otherwise be a quite polarized and polarizing, kind of narrative and discussion. So some very interesting points. I think we are a little over time, but I'd like to take a few extra minutes, if I may, for some questions in case there are any coming out of that very rich presentation. So any questions, please? Feel free to put them in the chat. Or otherwise ask them directly if you wish.
Please do. Professor Amelia.
Okay, thank you very much. That was fantastic. Thank you so very, very much.
Thank you. Thank you so much.
But to kick things off, do you think that somehow, with all of these disputes, we've lost sight of what foreign investors do, which is they do business?
Mm-hmm.
And we seem to situate foreign investors as disputants, and we're focusing so much on that. Do you think that that perspective is impacting on all these so-called reforms going on? I fully agree with the recommendations you have and the suggestions that you have made.
Thank you so much. That is such an important question. And again, it is a sovereign reflex to say the public interest, the government interest, is above and more important than any private interest, which is true when it comes to really significant matters. But at the same time, when a government undertakes as a sovereign in these treaties, still for its own interest, to provide certain protections to investors coming in, and then to give them a neutral international mechanism to protect them and to find remedies, then any conversation about reforms and any challenges in the framework, which again are not deniable, cannot fully ignore the perspective of the investors. Reforms of substantive treaty provisions also need to take into account what is it that does not fit? What is it in the government conduct that is clashing with these investment protection standards, and that the investors see as harmful, not only economically, but also for their own business operations? Because long-term investments require stability. And unfortunately, especially now in the renewable energy sector, I have seen analysis saying that governments need space for policy experimentation. Now, for a renewable energy investor, which comes in with high upfront costs in a sector that's highly regulated, very much dependent on the stability of the legal system, and then has to face the reality of regulatory experimentation. This is where you lose sight of the business aspect of foreign investment. Foreign investors come to your government, yes, they can and should contribute to the economic development, especially in the energy transition space. But then if you disregard the business side by chasing goals and chasing issues that are bigger than business, by harming business and alienating those you need for financing the kind of progress you want, I think that is the biggest tension that we face today. And it's a shame that in these discourses, usually organizations representing the business sector have to ask for participation. They have to ask and come in if they're allowed. The space for them to actually discuss viable options, collaborative models, ways to keep their businesses going and contribute to the state's goals are not as heard. And this also goes then to the inclusion of affected communities. There's so much to do, so much better communication to be made, so much better guidance to be given to tribunals of what to consider, how to consider it, and hopefully to detach the ability of affected communities to participate in these kinds of disputes and policies from the agenda of whatever NGO or whatever single interest organization might piggyback them into an arbitration, trying also to get their own submissions in on a certain issue. So absolutely, that is such a crucial point. And for now, it has been on the sidelines, but hopefully we'll see more of that as governments evolve their policies.
Great. I'd just like to bring in one more question, if I may. I see Stephen Finizio, who's the Deputy Director of the Centre, has his hand up as well. So please, Stephen, you have a question.
Hello, Stephen. Lovely to see you. Almost. Hold on.
Hi, Fahira. And it was a fantastic presentation. I actually have a really simple, but I think really hard question. What are your thoughts on practical ways to encourage the collaboration that you identified? I mean, you've given all the reasons why there should be collaboration. What are some ways that the current impasse, which I think has led to sort of real negative approaches by states in particular when they think about this, and maybe I'm putting the onus on the state because they're the repeat actor, where an investor may be one off and not thinking in terms of this. But could you give us more thoughts about how we might break that impasse and what sort of practical ways there might be to not just explain why collaboration would be good, but actually get that dialogue going? I don't think, in my experience, things like the institutional process, the working group process is encouraging that. And again, you don't have the individual investors there anyway. It's a state-driven exercise. So, do you have any thoughts about ways to do this? Is it happening on a local level, and are there ways to do it on a local level?
Well, actually, it is, and this is what I mentioned: the preliminary, all the unexplored areas before the actual filing of an arbitration and a legal dispute, all the unexplored space and opportunity to mitigate, address, and normalize communication. So it's no longer you come in, you are under our rules, and we let you do your job, we do ours. But then as soon as something is disbalanced, we are in our silos with lawyers. That has been the practice so far.
And that makes sense to me. I guess I was thinking about systematically.
No, I'm getting there if you want.
Yeah, please.
Literally, this is what we're doing in this region. So basically, developing communication roadmaps. And this does not mean you have to establish new organizations, new agencies, new competencies, or treat investors, with some kind of gloves, but simply to empower, for example, the foreign investment protection agencies to not only in the conduct of their daily work with investors to provide them their services, but also to serve as the first alarm bells to the higher institutions when there might be a problem, and then to open the channel for communication there. And this is envisioned as an actual process, as an actual grievance mechanism. So we are trying to nip in the bud the problem without letting things escalate, and then having ready a coordination body of institutions that can then come in as issues become more complicated, but that the investor knows, and hopefully, this mechanism will be mentioned in the treaty itself, that the investors know they have a responsive, identifiable channel to discuss and to bring to the attention of the government anything that they might need, including recommendations and things that they see in their policies or in the way things are operating that need to be reformed. And this could be the on the ground way to identify things that could be over time through proper tracking, be identified as trends, and then reformed in a more policy level perspective. But without communicating it in any way, if we are guessing through our perception and through our general negative attitude towards this liability and the payments you have to make and the sacrifices of the government, the silos will remain, and the impasse will remain an impasse. You need to be willing to open up the space in order for that to happen. You cannot be standing, two sides of the wall and then wait for something to happen. There has to be an effort, either just through vocalizing in the beginning, or to start digging, or to start tearing down together. That's what I'm saying.
Fahira, I'd like to thank you very much again for not only a very interesting and wide-ranging talk, but also ending on a practical and a positive note, which is really, really, I think, appreciated by all. So thank you so much. I know the conversation could go on. I hope it will go on separately as well. But thank you again very much for this excellent webinar. I think, as I said, this is the last webinar of the academic year. The next one will be by Haneen El-Hajalan. The title is still to be confirmed. It's going to be on the 18th of September at 6 p.m. Please have a look at the SA-DRC website, and also you can sign up to be a member if you're not already. So thank you again so much, Fahira, for a really excellent presentation. And on behalf of everybody, thank you.
It's been a pleasure. And just a note, so would you be able then to share the slides with everyone afterwards? The ones that I shared.
Hannah, you'd be able to do that, wouldn't you?
Yeah, we're gonna send that to the
I see
email.
some questions also in the chat, and I saw Ms. Makouf's hand up. I would hate to miss these opportunities for discourse, and Stephen as well. Also, if you need to dig into this topic some more, please reach out to me in the email that's on the last slide. We can schedule a quick call, or I will respond to emails. Like I said, this topic is just so rich, and I'm always curious to hear others' positions and then to share whatever I might that might be useful. Thank you.
Wonderful. Thank you very much. Bye-bye.
Bye-bye.